Howdy, folks. This is Kyle Graves. Today, we're going to talk about 5 legal issues that every space technology company needs on its radar. So, why don't we talk, legally speaking, about what happens when a significant portion of your company's technology isn't on Earth anymore, and how this will introduce novel considerations to your legal strategies. I'm not talking about launch licensing, and my prior work has delved much more deeply into Article 8 of the Outer Space Treaty, flags of convenience, things like that. But today I want to focus on the operational legal headaches that come after your hardware is in orbit on the moon or beyond, and as you're operating as a going concern in space. So issue number 1 is matters of jurisdiction and the continuing supervision obligation. Now, under Article 8 of the Outer Space Treaty, the state of registry retains jurisdiction and control over objects launched into outer space. This sounds straightforward until you realize what continuing supervision actually means for your day-to-day operations. If you're a U.S. company, the United States is responsible under international law for your activities in space in a way that is very similar to that associated with international shipping and aviation activities, and these are well understood areas of law. However, where this gets complicated for new space technologies is that flagged vessels from different countries are likely to interact in space, and they're likely to interact in new ways. For example, what if your technology is servicing another nation's satellite? What if your orbital platform hosts payloads from companies that are registered in different countries? The jurisdictional layering becomes complex in space. You could be subject to the regulatory requirements of your home state, the state of registry of the object you're interacting with, potentially the states whose nationals are using your platform. There's no single international authority resolving conflicts between those regimes, so companies need to build compliance architectures that account for multiple, potentially conflicting obligations and that do so at the same time. The name of the game here isn't 100% compliance, it's not 100% certainty, but rather intelligent risk management and looking for good opportunities to work together with your industry partners to develop new shared standards, tribunals, and treaty frameworks. Alright, issue number 2 is that of liability for orbital debris and collision events. The Liability Convention in 1972 established a 2-tier liability regime. Now, in one tier, for damages caused on the surface of the Earth or to aircraft in flight, launching states face absolute liability. In the other tier, for damage caused in outer space to another space object, it's a fault-based standard. Now, think about what this means for a company with dozens or hundreds or even thousands of assets in orbit. Every one of those objects is a potential source of liability, and orbital debris is not always entirely mapped. Because you're maneuvering around tracked debris, you may also be dealing with decisions, sometimes on a very short timeline, about whether to move your asset or accept a risk, and whether moving your asset might introduce new risks related to untracked debris or untracked natural things out there in space. Tort law will need to develop new frameworks. Tort law will need new frameworks for assessing liability in compound risk environments. These compound risk environments are very often predicated on an assessment of reasonableness and the reasonableness of your response to a risk scenario. This is very well-trod case law. Tort law has a variety of different frameworks of assessing this type of relative exposure. But when you're off planet, the fact-intensive inquiries can become very novel. And as we know, tort law is very often highly interested in specific competing sets of facts to assess liability, not from the perspective of assigning fault, as in a moral fault framework, but assessing economic liability. And there's going to be a lot of new questions regarding particularly what a reasonable actor would do in a space environment. So here you've got legal exposure. Legal exposure is running in two directions. First, if your object creates debris that damages another state's space object, then your launching state may face a claim. And very often these states will then look to you for indemnification, whether formally or whether functionally, since they control access to launch licenses. Indeed, many launch licenses contain indemnification provisions that flow the liability back to the operator of the vehicle. And then the second piece of this is that if someone else's debris were to damage your asset, your path to recovery is murky, particularly if that related launching state has reasons to impede your recovery. The liability convention operates state to state, so you would also need your government to bring a diplomatic claim on your behalf. There's not a lot of case law here. There is one instance in 1978. The USSR settled a claim from Canada relating to the crash of Cosmos 954. This scattered some uranium-235 over Canada, and there was ultimately a claim brought and settled. We don't have a lot of other cases that we can draw good analogies from. And as you know, when state-to-state interaction becomes necessary, there's a whole other cascade of diplomatic issues that may affect a state's willingness to really go to bat for you. So companies are going to need robust conjunction assessment capabilities, meaning you're going to have to do some of your own collision avoidance work. They're also going to need clear internal protocols for maneuvering decisions, and more than anything, insurance structures that actually reflect the risk environment of whatever orbital regime your payloads are operating in. Okay, legal issue number 3, export control and technology transfer in multinational operations. Under ITAR and the Export Administrative Regulations, EAR, a deemed export occurs when controlled technology is released to a foreign national, even if it never leaves the United States physically. Now extend that principle to space. If you have a platform in orbit and a foreign national's payload is operating on that platform, or if a foreign ground station operator is receiving telemetry from your spacecraft, then you need to think very carefully about whether controlled technical data is being transferred. The fact that the hardware is in space doesn't exempt you from export control requirements. The regulations follow the technology and the information, not the geography. This gets even more challenging for companies pursuing things like in-space servicing, assembly, manufacturing. If your robotic servicer approaches and interacts with a foreign registered satellite, then the technical data generated during that interaction, the orbital parameters, things like system configuration and performance characteristics, all of this information could constitute controlled technical data depending on the classification of the spacecraft involved. Companies operating in space need robust technical control plans. They need clear data segregation architectures and often technical assistance agreements or export licenses running at the same time. So be wary of export control and technology transfer when your space vehicle is interacting in some way with a space or ground asset associated with another jurisdiction. Okay, point number 4. This one we've talked about in previous episodes. This is intellectual property protection for off-planet technology. So I want to posit a question. This question doesn't have a clean answer, but it helps begin the issue discovery around protecting IP in space. So, where would an invention be made if it's manufactured in orbit? Is it made within the territory of the flag nation on the vehicle? Is it made somewhere else? What if it's made by multiple actors in concert? These are thought experiments that, again, don't have a whole lot of clear, practicable, actionable guidance based on real scenarios having played out in the past. This is all very new stuff. What if it's a process and it's being used in space? What if it's a process and it's being used on the surface of another terrestrial celestial body? We don't quite know. The United States Code 35 USC Section 105 does provide some patent protection for inventions made, used, or sold in space on a space object or a component that's under the jurisdiction or control of the U.S. So this is my initial query. Where is the invention made if it's manufactured in orbit? Well, if it's a U.S. space vehicle, it's made in the U.S. But that's just the U.S. That's helpful, but it's limited. So I'd direct your attention to my earlier material for more on patents in space. It's really, more than anything, a collection of dot experiments and then recommendations for practices that you can implement to help shore up your protection. But again, intellectual property protection in space is evolving, and other countries may not have the same coverage for those types of inventions that 35 USC 105 does. All right, here's the last. This is number 5. I want to talk about regulatory gaps in space resource utilization and how this relates to your property rights. So in 2015, we got the U.S. Commercial Space Launch Competitiveness Act. It says that U.S. citizens can own resources they extract from asteroids and other celestial bodies. Other nations have similar frameworks, but the operational problem is that these national frameworks don't create an internationally recognized property right. They create a domestic authorization, and other states may or may not respect that authorization. So if you're investing a whole bunch of money in an orbital manufacturing facility that relies on extracted resources as their feedstock, your business model then depends on a property rights framework that is evolving. The regulatory gap extends beyond resource rights. For instance, there's no comprehensive global framework governing things like orbital habitats or commercial activities on other natural bodies. National regulators are playing a little bit of catch up here. In the United States, the FAA has authority over launch and re-entry. The FCC handles spectrum. Other regulators handle other pieces of the issue. But if you're manufacturing off-planet, if you're manufacturing regulated things like pharmaceuticals in microgravity, well then who controls and regulates that facility? Who inspects that facility? What safety standards apply? The regulatory uncertainty around an operational infrastructure that's off-planet is really unprecedented. In this case, the regulatory uncertainty creates a capital allocation problem, particularly with investors that want to price in the regulatory risk as they commit money to orbital or lunar facilities. And it's pretty hard to price that risk because many of the issues will be issues of first impression. So there you have it. That's 5 operational legal issues that every space tech company with significant off-planet assets ought to be thinking about. Things like jurisdiction and supervision, debris liability, export controls, IP protection, resource rights, regulatory gaps. The common thread through all of these is that space law was written in the 60s and 70s for a world where really only governments operated in space. But as the commercial reality outpaces our legal frameworks, we find that companies operating today are building in an environment where the rules are still being written. So that's a risk, and it's also an opportunity if you're willing to take on the execution and compliance risks as those rules take shape. One would be prudent to become significantly engaged in the political process and look at these questions as a matter of risk management and risk pricing rather than seeking the type of regulatory certainty that many established industries have grown comfortable and have built a slate of advisors who can help with. It's a little bit different. So there you have it. This is 5 legal issues that every space tech company needs to have on its radar. This is Kyle Graves. You can find me on LinkedIn. You can find my regular content at kylewgraves.com. You can find my space content at spacelawdigest.com.